Don't the remarks have to be severe and pervasive? Isn't it? If all you had was 3, however offensive remarks, that would not in itself create a hostile work environment.
That's not what the courts have said. In fact, it's not just 3 comments. As we point out, one of the comments was said twice to her. Another comment was said 4 times. In addition, they're work-related. The courts have always said you have to look.
That's really 2 different questions. One, you're saying it's not just 3. If it were just 3, aren't the cases to the effect that 3 over an extended period of time, however revolting the comments that are in themselves, don't create a hostile work environment?
No, the courts have really not said that. But the courts have said you have to look to the individual case to determine that. For example, it's much different if you have a coworker making racial epithets to you than having not only your supervisor, but the head of the department saying it.
What is the effect of her resignation on this case?
I don't think it has any bearing because she was terminated in writing by the employer. That goes on her employment record. That is clearly a tangible employment action. They have never rescinded that termination.
Approximately how long after the last epithet did the termination take place?
The termination occurred approximately about a year and a half later, a little bit more.
As I understand, I'm sorry.
I was going to say, the Appellate Division separated out the racial epithets from the other.
And we think that's the central issue in this case, Your Honor.
Okay,
The central issue because, for example, it's like
What is the central issue?
The central issue in this case is that, and a clear reading of the Appellate Division, and with all due respect to the Appellate Division, is they separate out the 3 racial comments from all the other conduct that occurred. The courts have said, and there was one good case that talked about the fact it's like looking at a play and looking at Act 1 and not looking at Act 3. I would say it a little bit differently. I'd say it's the equivalent of having a critic go in and review a play and say, I'm going to review Act 1, and then I'm going to separate that out and say, I'm going to forget about Act 1, then I'm going to review Act 3. You can't do that. The workplace is a living, breathing environment. And that is not the only thing that occurred to her. For example, she and another black employee, who were the only black employees in their department, the same supervisor who made the racial epithets circled her name and the other black employee's name on
Wasn't there some
timesheet.
issue of tardiness as to the 2 of them?
They're alleging that it's tardiness. In fact,
Did she circle the name or the arrival time?
She circled the names. The names.
Where is
those
that?
2 employees. Both employees went directly to her and complained about it. You know what she said to them?
You're claiming
There
that
were
the
3 epithets that you're referring to, all in the fall of 1992.
Yes.
Correct me on this, if you would. I have it that she filed grievances in October of 92, November of 92, and December of 92.
She filed even prior to that. She was
even
filing
prior.
all the way from July of
Yeah,
92
July
through
9.
December.
Yes, harassment, grievances with the union. So I have
Not with the
4.
union, with the employer.
All right.
The grievances were filed with the employer. Harassment, she used the words harassment,
Right,
bias, discrimination.
right.
If the disciplinary actions occur, they all occurred starting from about 9/25, if I'm correct, of 92 until about 12/23 of 1992. So all of a sudden, she became a terrible note writer. And she says that that's not correct. Because what happened was, she wasn't the only one writing notes. These notes were written sequentially. This is why it's important that these matters go to a jury. These notes were written sequentially. Every 2 weeks they would write notes. She wasn't, there would be people who had to write notes before her. They hadn't done it.
Well, they say that when they called the father's house, he said, well, she's going to Hawaii.
And why did she go to Hawaii? Because her brother lives there and her father's extremely ill and she needed to go to Hawaii to talk to her brother about her father, as you would have to do in families with an extremely ill parent. They're trying to portray this like she was having a luau in Hawaii.
Well, couldn't they, those, do you?
No, but those are the facts that encompass each one of those claims, and many of them encompass more than one claim. Because there's no, which is exactly what the point is here, there is no you can't put up artificial walls and say, well, just look at the comments here and then put them aside, and then look at this here and then put that aside. It doesn't give you a realistic view, and the cases that we've cited, and we've cited many of them, talk about that. And in fact, even on the issue of hostile work environment, the Richardson case, which is a Second Circuit case, talked about the fact that the marker of what has been considered previously as being outrageous conduct or conduct that would be hostile work environment is not necessarily what the marker is. You have to look at each case individually. Here, for supervisors to make the kind of racist comments in addition to the other conduct is clearly, we would respectfully argue, not even a close call. That's something a jury can determine.
Thank you, Mr.